Hi, my name is Sharmin Anwer. I'm an attorney with Cobb Legal Aid, and I handle the Lawyer in the Law Library program, where I provide free 30-minute consultations to qualifying individuals on qualifying matters every Monday through Wednesday from 9 a.m. to 4 p.m. And today I will be giving a presentation on protective orders. So just a little background about Cobb Legal Aid. We are a nonprofit law firm that provides free legal assistance and advice to low-income individuals on basically civil legal matters for those who live in Cobb County or have Cobb County cases. Of course, we serve individuals based off of their income. Income eligibility is linked to the federal poverty rate. And as I said, applicants must live in Cobb County or have a Cobb County case. When should you call legal aid? If you are being evicted, if your landlord refuses to make repairs, if you're experiencing domestic violence, if you are disabled, child's educational needs are not being met, or if your public benefits were terminated. Cobb Legal Aid does intake and screening every Monday through Thursday from 9 a.m. to 12 p.m. by phone. You can also do an online intake for non-urgent matters. But for urgent matters, an online intake is appropriate. They also do walk-ins as well. Just a few disclaimers. This is a general presentation about Georgia law, and it may or may not directly apply to the facts of your case. So for specific advice about your case, it is important to consult with an attorney. As I mentioned, you can call Cobb Legal Aid, or you can go to Cobb Legal Aid's Lawyer in the Law Library program, which is where I am, and if you qualify, I can give you a free consultation and give advice specific to the facts of your case. So as I'd mentioned, we're going to be talking about protective orders today. So what is a protective order? A protective order restrains the accused person from harassing, stalking, or threatening the physical safety of the person who filed the protective order. And there are several different types of protective orders, which we'll talk about. A couple of words to go over. The petitioner is the person who's filing the protective order, and the accused is the respondent. So throughout the presentation, you'll hear me say petitioner and respondent. So petitioner is the person who's filing it, and the respondent is the accused. So as I'd mentioned, there are a few different types of protective orders. There's the family violence protective order, stalking protective order, dating violence protective order, and employer protective order. And we will be talking about each of these. So the first one I want to talk about is the family violence protective order. And before I get into it, I kind of want to talk a little bit about domestic violence and what it is. So domestic violence can be defined as a pattern of behavior in any relationship that is used to gain or maintain power and control over an intimate partner. It's important to note that domestic violence isn't always just physical. It can be economic, sexual, it can be psychological actions or threats of actions that influence another person. And domestic violence can really happen to anybody. So it's important to keep these things in mind. So the Family Violence Protective Order is codified in OCGA Section 19-13-1, and this created a civil cause of action by a victim of family violence against the survivor's aggressor. So the victim of family violence can petition for a protective order against a spouse, family member, or household member that has committed an act of violence against the petitioner. So it's important to note that not only does a family violence protective order restrain the accused from engaging in certain behavior, but it can also create other remedies, such as creating a child custody order or some kind of financial support order as well. And we'll talk a little bit more about that. We'll talk about the process of a family violence protective order. The first step is to file a petition. The next step is an ex parte hearing, and then there's a full hearing, and we'll talk about each step. So as I've mentioned, the first step is to file a verified petition or to complete the verified petition. And in order to do that, you need to have some form of identity. So, like a Georgia driver's license is sufficient. You need to be able to also provide information about the respondent, so about the accused. Important information like their demographics, such as their name, last name, date of birth, their home address, and contact information. Now, you may be required to provide proof of a familial relationship because, as I'd mentioned, family violence is for situations where violence occurs within the family. So you may need to prove that there is a family relationship. And then you'd also need to provide evidence that is specific and clearly documented of the violence. So whether that's pictures, testimony, whether that's witness testimony as well, something to show, specifically what has happened. So when you complete the petition, you file that in the TPO office of the magistrate court. And here it's on the 4th floor of the magistrate court here in Cobb County. And you file the petition in the accused or the respondent's county. But if the respondent lives outside of the state, then you would file the petition in the county of the petitioner, so where the petitioner resides, or where the act of violence happened. And anyone over 18 can file this petition, but if you are under 18, then they would need someone who's above the age of 18 to help them file that petition. It's important to note that here in Cobb, there are legal advocates from Live Safe Resources who can assist in preparing the petition and accompany client to ex parte hearings. So there is some assistance there. So once you file the petition, there would be an ex parte hearing, and an ex parte hearing occurs without the respondent there. So the accused is not there, and this can happen pretty quickly. The hearing could happen on as early as the day the petition is filed. And again, the respondent is not notified of this and does not attend the hearing. So the judge will review the petition and the evidence and make a decision. If an ex parte order is granted, then the judge will order the local sheriff's department to serve the respondent with the ex parte order. And this is effective for 30 days until there is a full hearing. And the reason it's called ex parte is because the other party is not there. So as I'd mentioned, the ex parte order is effective for 30 days. After that, there will be a full hearing. And the hearing must occur no later than 30 days after the filing, unless otherwise agreed upon. At the hearing, there'll be an evidentiary hearing. The respondent should be there as well to present their case as well. The judge will review the evidence, will review the testimony, witness testimony, and make a decision as to whether the order should be granted. Then the allegations must be proven by preponderance of the evidence. And if there's insufficient evidence to support a protective order, then it would just be dismissed. It would not be granted. So as I'd mentioned, in an ex parte or in a protective order, you can also get custody and visitation and child support. This is important because sometimes when two people are married, they may want to separate, but they can't get some kind of custody order in place until maybe a divorce is filed. But if there's some kind of family violence going on and the petitioner would like to have primary custody of the children or the child during the pendency of the order, then that's something they can seek in the petition. So it has to be specifically asked for when the petition is being filed. And whenever we're talking about custody, the court's always looking at the best interest of the child standard. And the best interest of the child standard looks at stability, it looks at safety and health. And so if the petitioner is seeking primary custody of the child and they plead for it, then the court can award primary custody of the petitioner so long as there's no findings that it would be in the best interest of the children to be with the respondent. So what that basically means is the court would want to make sure that it's in the best interest of the children for the petitioner to have primary custody, and that it wouldn't be in the best interest of the children for the respondent to have that primary custody So again, looking at things at safety, health, stability, comfort, consistency. And you may wonder, well, what are those situations in which a custody order may be issued within the protective order? Well, you're looking at situations where did the children also experience some abuse by the respondent, or did they witness the abuse that the respondent allegedly did to the petitioner? So those are some things that the court looks at. And the order has to provide for the safety of the children, so that's very important. So again, if that's found, then the petitioner can get primary custody of the children, and there can be a visitation schedule put in place. Visitation is appropriate if children will not be in danger and respondent is the legal father of the children. So keep in mind, in Georgia, when children are born out of wedlock, the mother has sole physical and legal custody until the biological father goes through a process called legitimation, in which he is recognized as the legal father. So that's something the court is looking at. Okay, if the petitioner is the mother and she is seeking primary custody of the children, has the father legitimated the child? Is the father the legal father? Does he have rights to custody, legal physical custody of the children to begin with? So that's something that the court looks at too. And the visitation schedule has to be specific. Some things to keep in mind, if there is an exchange that happens where the children are dropped off or picked up, it's important not to do it at the place of residence. It's important to do it in a public place, maybe have someone there who could safely help with, the exchange of children, maybe at like a gas station or a McDonald's or something like that. And as I'd mentioned, you can also get child support through a protective order. Again, it must be pled, so it must be asked for. And child support, this is discretionary, so that's important to keep in mind. And if you were to get a child support order, you would need to do the child support worksheet to help figure out what that amount would be. So, as I'd mentioned, protective orders can have several remedies. We talked about how, of course, the remedy of a protective order is to have a restraining order, so no contact, restraining from certain behavior. We talked about how it also can provide for custody of minor children, visitation, child support. A couple of other remedies also available would be possession of home or other property such as a car. So let's say you have a protective order, but you need to be able to get to the house, or you need to be able to have access or possession to your car, and it may involve contact with the respondent. So it allows for you to be able to get possession, vice versa, alimony or other support, like payment of rent or mortgage utility. So while the protective order is in place, it may allow for, that payment system. Exchange of personal property, again, if one person has personal property that the other needs. Counseling, costs like attorney's fees and other remedies as appropriate. So that was family violence protective orders. The next protective order we're going to talk about is a stalking protective order. So what is stalking? It's following another person, placing another person under surveillance, contacting another person without their consent for the purpose of harassing and intimidating the other person at or about place or places. Place or places includes any public or private property occupied by victim other than residence of defendant, for the purpose of harassing and intimidating, and it serves no legitimate purpose. Unlike a family violence protective order where a relationship is required, here in a stalking order, no relationship is required. Georgia law defines harassing and intimidating as knowing and willful course of conduct conducted at specific person, causes emotional distress by placing in reasonable fear for their safety, by establishing a pattern of harassing and intimidating behavior, again, serves no legitimate purpose, and there does not need to be an overt threat of death or bodily injury. So that was a stalking protective order, pretty short and simple. The next one I'm going to talk about is the dating violence protective order, and it's pretty much similar to family violence protective order. It's just that it's its own thing, where it's for if it's not part of a family violence protective order, even though it operates similar to it, but it's kind of its own thing where you can file for a dating violence protective order against a person who you are in a relationship with, though not like a familiar relationship, but you're in a relationship with, or who you had a relationship with in the past 6 months, or when a pregnancy develops from a dating relationship. So those are the three circumstances we're talking about when talking about a dating violence protective order. It allows victims of dating violence to seek and obtain immediate relief in the form of a temporary protective order. And again, it can be issued by the court without allowing the accused to be there, so it's ex parte. And an important thing is that it can allow, the court can allow the accused to go through some type of counseling or participate in some kind of educational program regarding that kind of DV run by the state. And what does a what does a dating violence protective order, what does it protect against? So it protects individuals from simple assault or battery, aggravated assault or battery, stalking, felony offenses. Some of the remedies that are available under this, it directs the respondent to refrain from such acts. It provides for possession of personal property of the parties. It can order respondent to refrain from harassing or interfering with the petitioner. It can award costs and attorney fees to either party and order the respondent to receive appropriate psychiatric, psychological, or educational services as a further measure to prevent the recurrence of dating violence. And the last one we're going to talk about is the employer protective orders. This is OCGA section 34-17. Any employer whose employee has suffered an unlawful violence or credible threat of violence from any individual, which can reasonably be construed to have been carried out at the employee's workplace, may seek a temporary restraining order and an injunction on behalf of the employer prohibiting further unlawful violence or threats of violence by that individual at the employee's workplace or while the employee is acting within the course or scope of employment with the employer. So that's a pretty short, simple summary of what the employer protective order or orders are. A couple of resources. So I mentioned here there's LiveSafe resources where there are advocates who could help with the petition. And of course, if your situation involves an emergency, call 911. There's also Partnership Against Domestic Violence. As I mentioned, I am in the law library. I run the Cobb Legal Aid's Cobb Lawyer in the Law Library clinic which is on the 4th floor of the Superior Court in the law library. There's also the Cobb County Workshop, Family Law Workshop, and Fulton Family Law Information Center. So there are several resources out there. Again, calling legal aid is an option too if you have more questions about protective orders. And thank you so much.